Good afternoon, everybody. Thank you so much for your time and joining us today for our conversation about getting teen privacy rights. I think we're going to have a really exciting and important conversation today with regards to teen privacy, the evolving policy and legal landscape that continues to be more and more complex each and every day. So I would like to first start with introducing my esteemed panel. For those of you who don't know, my name is Donna Frazier. I'm Senior Vice President of Privacy Initiatives for BBB National Programs. We are, for those of you, again, who don't know who we are, we're a nonpartisan nonprofit whose mission is to enhance industry self-regulation through a multitude of business resources, including our certification and accountability programs. With me today, I have the opportunity to speak with I think, a really interesting, well-informed, educated panel. Our speakers today include Jessica Rich, who is of counsel and senior policy advisor for consumer protection at Kelly Dry Warren. We have Michael Murray, who is head of regulatory policy at the UK's Information Commissioner's Office, the ICO. And we have Russell Hanser, associate administrator for National Telecommunications and Information Administration, NTIA. Russell is doing us a huge favor by stepping in Travis Hall's shoes, who unfortunately was unable to join us today due to flight delays. So life happens and we pivot. So Russell, thank you so much for joining us at the last minute. I want to remind people who have joined us that if you have any issues with regards to you're not able to hear or see something, or you want to submit questions, whatever it is, please email events at bbbnp.org. Again, that's events at bbbnp.org. So let's just jump right into this. We can skip forward a couple of slides. Yeah, we can go to the next slide. So thank you. So again, today we really want to discuss some of the important policy developments that are taking hold across the globe with regard to teen privacy protections and how businesses can begin to really look forward on how to deal with compliance considerations. And I think we need to take this one step at a time, right? Starting with the global angle, talking through what we're seeing in the UK and the US. We know that a lot of companies are paying very close attention to what the UK is doing and holding the bar there. And then I think we will discuss what sorts of practical solutions are out there with regard to the patchwork of privacy laws that are on the horizon. So we can go to the next slide, please. So I think this slide can sometimes, I think, be a little overwhelming, right? I think the wave of legislative and regulatory activity in the teenage privacy space has encompassed the globe, right? Here in the United States, we're paying so much attention to COPPA, the Children's Online Privacy Protection Act, for so long. And we now know that there's been an explosion both here stateside and outside the US with regards to new state consumer and teenage data privacy laws that are taking effect both here and outside the US. What's not on this screen, because it's constantly evolving and changing, is China. Their recently adopted law, which is places exact requirements on the number of hours that different age groups can be on social media. What's also not here is Canada's Office of Privacy Commissioner just adopted 2 guidance documents supporting its recent joint resolution with provincial privacy authorities to improve children's privacy standards. One guide focuses on considerations for the best interests of young people, I'm using air quotes there, in data processing activities, while the second guide offers recommendations to organizations on best practices for protecting children. By the way, any guides or resources that we mention in today's webinar, you will receive, upon completion of this webinar, a detailed list of all the resources pointing to all the guides, everything that we talk about, so that it's available to you. So what is on the screen also, we talk about India's data privacy law, which places really important expectations on businesses to protect minors by requiring parental consent for under 18 users. And while US federal privacy legislation, was introduced to uphold stronger data privacy protections when processing personal information from that 13 to 17 teen group, um, there has not been any formal action. There's been nothing formed and passed out of Congress, leaving the opportunity for precedent to be set by the FTC and its enforcement actions. And we've seen this happening. And it's also allowing states to take a more critical role in determining best practices. And we're seeing that too. So the self fulfilling state patchwork results in this level, I think, of confusion, what the rules of the road are for consumers and for businesses alike. The state patchwork is becoming more and more difficult for companies and consumers alike to really address. So again, this is where self-regulation, organizations like ours, can play a key role in helping companies really figure out how to be accountable, how to show that their work, as I often say, and set the stage for a more uniform set of obligations that really take the entire landscape and the patchwork into consideration, but also try and level set what industry is trying to do without chilling innovation. We want to see innovation in this space. I think all of us on this call would agree to that. So, Michael, I want to start with you. Let's talk about the global approaches to teens. The UK Children's Code has been one of the earlier thought pieces on children and teen privacy. It's led the way for other privacy regimes, of course, starting with California. So, can you share with our attendees, especially those that may not be as steeped in privacy, what the Children's Code is, how the Children's Code has shaped the regulatory environment for businesses and are likely to serve children and teens?
Thanks, Anna. Certainly. Just one point also on the slide you have, we're not seeing a lot of the other content-based regulation that's also affecting this space. So here in the UK, we have the Online Safety Act, which is now passed through Parliament and also adds a layer of protection on the safety side of the agenda for teens. That is now law in the UK. I won't go into the details of the OSA, but it focused more on the data protection side. The Children's Code, otherwise known by its official name, the Age Appropriate Design Code, is a code of practice. It's a how-to guide setting out 15 interlinked standards of age-appropriate design for online services which process children's personal data. Now, this is important. The code relates to personal data protection only. It does not attempt to regulate content, which in the UK is within the remit of our colleagues at Ofcom on the Online Safety Act. The code is grounded in the provisions of the United Nations Convention on the Rights of the Child and creates an open, so transparent and safer place for children to play, explore, and learn online. Also really critical, our previous commissioner, Liz Denham, was really keen that the code is designed to protect children within the internet and not gate them out of it. And that is our intention with the code as well. It applies to what we call in the GDPR relevant information society services, which are likely to be accessed by a significant number of children in the UK. And by children, we use what the UNCRC defines as a child as anyone under the age of 18. The standards of the code are rooted in existing data protection law in the UK, and these are introduced by the Data Protection Act in 2018. It's designed to help online services understand how they can comply with the UK GDPR, and any regulatory action that the ICO takes in relation to the code is only possible through data protection legislation. So we're regulating and supervising on the UK GDPR, not on the standards of the code. That being said, if an online service is not conforming with the code, it's highly unlikely that they would be complying with the GDPR. So they're designed, the code is designed to sort of inform services how to comply. That's a really important distinction for the California Code, which is primary legislation. In the UK, it is a code of practice that backs up and helps explain the primary legislation, which is largely the UK GDPR. The code standards include default setting requirements, everything from having children's and teens' privacy set on high by default, geolocation, data sharing, profiling set off by default. Children should be able to change these settings if, for example, they're interested in receiving advertisements for products that they're interested in. But the choice is the child, not the online services. So the child decides if they want to alter those standards, and they should be again set at high privacy by default. There's also specifications that link to the UK GDPR, such as transparency, data protection by design and default, and the use of data protection impact assessments to uh, um, outline or detail the data protection processing that the service is undertaking. It also addresses age appropriate application, under which we include age assurance. The code's been in effect since September 2nd, 2021, and is already generating visible change in behavior across big tech platforms and smaller online services. We did an evaluation of the code, which shows about half of online services feel that they are fully compliant. Now, whether or not that's completely accurate is still to be determined, but it shows a level of awareness and progress towards complying with the code. We're impressed by some of the changes we've seen, including targeted and personalized ads being blocked for kids, children's accounts being set to private by default on TikTok, for example, and default plus location history being turned off by default. Adults also being blocked from directly messaging children in the UK, and notifications at bedtime being turned off. So some of the things that encourage children and teens to stay online longer, to reduce their privacy and their protections, are being addressed through conformance with the code. Behavior is changing across big tech companies. So Google has turned off ads for under 18s. TikTok turned off profiles for under 18s as well, and they turned those to private by default. Snap, Instagram, and Epic Games have all made improvements to parental controls. Meta, Lego, Roblox, Sony, and many others have implemented new age assurance systems to improve identification of teen users or underage users' accounts, and to improve age appropriate in their systems. And we're also pleased that versions of the code appropriate to local circumstances have been adopted in the US and Europe. You mentioned the Irish Fundamentals, for example, which came into effect shortly after the code. We also see similar codes in Sweden, the Netherlands, and the EU is in the process of developing its own code, which hopefully will be in place next year. The core messages that we built into the code apply across all of those codes. So we're really pleased that the code has been sort of the start of a conversation with industry, to show and support industry to be innovative while also protecting children's privacy, and keeping kids online, and keeping kids able to use the services that they so much are interested in, and it's in their rights to use.
Do you do you observe a shift in how companies are actually, and the platforms are actually understanding and thinking about the fact that they cannot put the onus on the user or the consumer? Everything can't just be put on them, right? That they have a responsibility to provide these tools and resources. Do you sense that there's a shift in that beyond just mere compliance with the laws?
I think so. I think it's a tricky one, because our evidence and even recent Pew research shows that parents feel that they should have the fundamental role in looking after their children and determining what they see online. But at the same time, parents will also admit they don't read privacy policies. They don't understand sometimes how privacy um, how companies use data for their children, and they don't have time. And they're also often sort of impacted by children pressure to allow them onto services that are probably inappropriate for them. Parents tend not to recognize the risk of how children use services, thinking of how they use Facebook or how they use TikTok, or so on, rather than how children use it. So the idea of the code is to put the emphasis back on the company to conform. I guess it's a seatbelt sort of analogy, isn't it? So designing the safety into the system through privacy by design. And yes, we do see companies doing that more. It is a process. We didn't see full conformance to the GDPR within 2 years of it coming into law. It is a process of companies doing that. There's also, of course, a lot of legacy websites, legacy apps that companies need to progressively update, replace, and as those things happen, they are moving towards more privacy by design. Not everybody's doing it. Sometimes they need a bit of a push, and the ICO reserves the right to take action where it's required, and where we see the risk of harm being greatest to children. And in the UK, I'll talk about that a bit later on, but yes, we are seeing some change happening, but in some cases it can be a mix. I think most companies that we've talked to recognize that there's benefits of the code, and about 85% of the companies we've engaged with believe the code's had a positive effect on children's privacy.
Great. So we can pull the slide deck down so that, because I do want to pose this question, Michael, to you, but also would encourage Jessica and Russ to chime in as well with regards to the recent case that we've seen in California with the challenge, the net choice challenge to the age appropriate design code in California. Would open it up to you, Michael, to start, and Jessica and Russ, if you want to chime in as well with your opinions about where things have landed so far. I do want to note that, personally, I don't think the law in its entirety is going to go away. So if people are waiting for, to see where this whole thing lands, I think that we would encourage companies to still operate as though something is going to be in place, and that just merely waiting to see where this lands is not the answer, right? That companies really need to address this teen space and deal with it head on. But I'll turn it over to you all to chime in on that.
Um, I understand that there is an appeal being launched by the Attorney General in California, so that's useful to see. One, I'm not going to comment on the judgment. That's probably not my place to do so. But I think one cautionary element from me is California's online services. Um, their industry is highly effective and sought after across the world. So much of the law that's in California is similar to what's in the UK and in Europe. So the companies that would be, in many cases, within scope of the California Age Appropriate Designs Code are in scope of the Irish Fundamentals, are in scope of the UK code. So writing the DPIA, for example, or putting age assurance in place, or all the things that protect the data, the personal data and personal information of children in California also apply in the UK and vice versa. And it would be a shame if the California companies that are offering their amazing services to children in the UK aren't offering the same protections to the children in California. So we look in interest to see what's going to happen in that case.
So um, I want to add and expand on that. So it's very clear when you read the California Age Appropriate Code that it's designed after the UK code. I mean, there's so many common elements. Best interest of the child, DPIAs, age appropriate controls, establish age or apply protections to everybody, uphold your policies, high default settings, no nudge techniques, we call it dark patterns, et cetera, et cetera. But there's two essential differences. One is that the UK code tailored, and Michael has made this point, tailored its code mostly to privacy. And the California law was designed both to address privacy and stop harmful content.
Content, right?
And the second is, of course, that the UK code isn't, as Michael emphasized, isn't itself a law, whereas the California age appropriate code is, and that makes a difference too. So in terms of content, blocking and filtering content raises huge red flags under the First Amendment. And indeed, when industry groups sued to stop the California law, the court struck it down. And the law may have fared a little better if it had stuck to privacy. The judge saw those content restrictions. Frankly, the law is also drafted fairly loosely for a law as opposed to guidance, um, and had some vague terms. So the judge saw that, and I think she sort of said, "Hey, I'm just going to strike most of it. You know, it all looks terrible to me." But if it had maybe stuck with privacy, she might have left more there.
Right.
Um, and but this isn't an isolated instance. The other laws that are designed to shield minors from harmful content by um, saying you can't even access social media without parental consent, one of those has been struck down. Two, and also there's prominent bills in Congress, mostly, namely the Kids Online
Right.
Safety Act, which is in this space.
Mhm.
And that's been stalled because of some of the same content control concerns. But I agree that it doesn't mean these laws, the desire to protect teens is not going away. It's just the way these laws went about it. Um, Courts have found fault with it.
Rusty, do you want to chime in?
Just, I mean, Jessica and Michael, of course, covered it, covered the topic really ably. I'll just pull on one thread, which is the experience with the California code underscores that sometimes there will just be differences in fundamental legal obligations, constitutional, structural issues that play into difference in that create or lead to differences in policy. And without speaking to the net choice case in particular, or whether this particular law is or is not likely to present a First Amendment challenge, we do have this very strong First Amendment, strong and getting stronger as the way the jurisprudence is going, I think. And that's something we all need to contend with as we think about these content issues, including the teen issues, but also including other matters involving mis and disinformation and so on. We've seen this across the board. There's another set of cases moving through the courts on what government can or cannot say to companies and sort of trying to nudge a particular outcome. And this is just going to be a consistent theme in this set of debates on this side of the Atlantic.
Mhm. Great. Before we move on, I want to move to the work that you're doing at NTIA. But first, we did receive a question from the audience, Michael, that I do want to address very quickly. The question is, how are e-commerce companies dealing with the UK code, and are privacy controls on the lowest setting by default? So you want to take this in two parts?
Yeah. The e-commerce companies are within the scope of the code if children are accessing the services, so in significant numbers. So we haven't had any sort of supervision with e-commerce to date. We focused most of our attention initially on streaming, social media, and games, although the e-commerce will of course have children and teens using their services, so they would be within scope. I can't say for certain what the level of engagement is, but based on the evaluation of the code, we see e-commerce is engaging and is starting to follow the code. I'm sorry, I missed the second bit of that question.
No, the second part is, are privacy controls on the lowest setting by default? Is that
The privacy controls within the code, children's and under 18's privacy should be set at high by default. So in the example of TikTok, then we see the adults aren't able to find children easily if their account is set at high default. Now again, the child can change it if they choose, but the default should be privacy set at high. Profiling, geolocation, data sharing should all be set at off by default. So all those areas that children often have their data shared with third parties that they don't know about, off by default unless they choose to change it. And even if they do choose to change it, they should receive notifications to sort of advise them about whether or not that is the right thing to do.
Great, thank you. And again, I would encourage the audience to submit your questions. We will ask as we go along, so please do. So Russ, I want to turn to you to talk about some of the work the NTIA is doing. You've opened up a comment period to gather stakeholder feedback about the state of online mental health, safety, and privacy focused on social media platforms. So first, can you shed some light on how this comment period even came about? And secondly, what your plans are to do once you receive all that stakeholder feedback.
Sure. So, and thank you for having me. I should have said. Um, so early this year, we got outreach from friends in the White House who were looking at ways to enhance kids' online health, safety, and privacy, especially in light of the fact that the COSA bill was stalled, as Jessica explained, and they were looking for ways, excuse me, to move forward in areas that could be moved forward on without legislation. And one of the provisions in the draft of COSA, it's still in the draft of COSA, contemplated setting up, I don't remember if it was called a task force or something else, but contemplated setting up an interagency group that would look into some of the issues here and create recommendations. So we talked with them about what was feasible. I think they were talking with other agencies as well. And the result of that was a fact sheet that the White House released in May, which was Mental Health Month. And it listed various actions the administration was taking with respect to especially kids' mental health and a focus on online health. And there were various tasks for various agencies, but the first one was the creation of this Kids Online Health and Safety Task Force. It's an interagency group that was created. It is led formally by HHS and specifically the Substance Abuse and Mental Health Services Administration, SAMHSA, within HHS. And the language in the fact sheet is, I think, in close consultation with the Department of Commerce, in close partnership with the Department of Commerce. Um, so essentially from day one, when that fact sheet was issued, we worked closely and have been working closely with our colleagues at SAMHSA. So that fell to NTIA within Commerce. And we have organized and been administering effectively this working group, this task force which includes members from DOJ, DHS, the Federal Trade Commission, various other parts of HHS, NIST, also within Commerce. It's a collection of agencies listed by the fact sheet. And we're meeting very regularly, and we were engaged in various kinds of information outreach. The RFC, the request for comment, which we recently issued, is part of that effort. Is a big part of the information collection effort. And I'll get to what we're going to do with it. Well, maybe by way of talking about what we're going to do with it, I should talk about what the fact sheet asked of the task force. So, at a high level, the task force is charged with working to advance the health, safety, and privacy of minors online, with particular attention to preventing and mitigating adverse mental health effects. Sorry, the adverse health effects, not just mental health effects, of online platforms on minors. We're charged with identifying current and emerging risks of harm, and also potential health benefits of using online platforms. I think most of us agree, I'd hope most of us agree, there are minors in the US who benefit tremendously from online platforms and from access to people and communities that they may not have access to in the real world, in real life, as we used to call it anyway. So the task force is going to be recommending measures for assessing, preventing, and mitigating those kind of harms, and developing a research agenda regarding harms to fuel future work. I should emphasize that the task force does not have regulatory authority. What we issue will not be legal mandates or regulatory mandates, although we might wind up issuing recommendations for such mandates coming from entities that do have that power. Specifically, the outputs that have been asked of the task force are, this year we're charged with reviewing the status of existing industry efforts and technologies to promote health and safety. And by the way, I'm reading from the fact sheet, so if you go back and look, you'll say this sounds very familiar. Reviewing existing industry efforts and technologies to promote health and safety of kids and teens vis-a-vis online activities, especially social media and other online platforms. We're also charged with reviewing and compiling best practices to assist parents and legal guardians in protecting their kids' privacy, health, and safety. And then in the spring, we're charged with developing voluntary guidance, policy recommendations, and a toolkit on health, safety, and privacy by design for industry. Thematically, I'd say a lot of what we're thinking about is consistent with what others have said so far in this session. I think we are looking at ways to advise parents, but we're also thinking hard about making sure that the platforms themselves, which often are the ones in possession of the information and the ability to act, bear the appropriate burden themselves, and while maintaining parental control for the reasons Michael mentioned, that parents do want the ability to act, even if they're not always don't always have the time and resources to do so. So we're looking at all those things. In terms of what we're looking for out of the comments are due in about a little more than 2 weeks.
Mhm.
And we're looking for really a wide range. It's a wider range of material, I think, that we're looking for than often is the case for our request for comment, because I'd be very happy, and I hope we get comments that are deep in the weeds on psychological studies and how addictive behavior works, and how seeing certain body images affects teens' own body image. And we could expect some really deep scientific research to be submitted on those points. I also hope and expect we'll receive comments on what tools online platforms are using today, are making available to parents, what their
Right.
policies are on their presets and on privacy settings, and on what kind of anonymity they'll allow, what kind of age gating they engage in, how they effectuate that age gating. Those are two very different kinds of comments, but I
Mhm.
think the overall, if I had to summarize the goal of the task force in just a few words or a sentence, would be marrying up that research, that behavioral and other health research and privacy research, with real on the ground information regarding what is going on, what platforms are doing, and then what platforms could be doing to better preserve and enhance kids' online health, safety, and privacy. So I'm sorry to monologue for so long, but that's
No,
that's
no,
the gist.
no, no, no. That's exactly what we want. I think I agree with you. I think it's really important for the entire ecosystem to contribute to this comment period, because if it's so heavily weighed on the academia side, and the companies and the platforms are not contributing to this comment period, then that's whose voice is going to be heard. And again, I would encourage companies that are tuning into this to really think about whether or not they want to contribute to this comment period, because I think, look, companies are steeped in developing technologies. They are creating, solutions for privacy by design. They're dealing with these default setting questions. I think their contributions to this would be extremely helpful, to all of us. I would be curious to see it as well. So we did get a question that I do want to put in front of you all. So the question is, where have the codes, and specifically, I think speaking about the age appropriate, and probably California design code as well, where they landed on transparency and the need to tailor notices for audiences of various ages. So, if presuming that you know who your audience is, how are you seeing companies address their separate audiences with regards to transparency and disclosures? How are you seeing companies deal with this? And Jessica, you may be seeing this in your work as well, so I'll open this up to all of you.
Yeah, I want to address that, and I also want to thank you for having me too. One comment I wanted to make, just back from the beginning, is that thing you had about increasing regulatory focus. One other thing that's not on the chart, because you were talking about regulations, is the enforcement that the Federal Trade Commission and the states are doing under their general UDAP laws that aren't even codes.
Right.
The FTC brought the Epic case where it was protecting teens, even though it didn't have specific statutory authority to do that. It was using its catch-all authority. And as we know, the states just brought a very large action using their UDAP authority against Meta, under some
Right.
of these same theories. So that's just another thing that companies have to worry about and juggle as they try to understand this area. In terms of whether companies are, um, regardless of the California Age Appropriate Code did have you tailor your content and to different ages, and other proposals are doing that too. Um, and what companies are finding is that it's very hard without collecting a lot of information to do that. So many companies are just, anyone that they have information is under 18, they're going to treat sort of monolithically, which um, may not be the best outcome. But it's if it's going to now not stop at 13 the way it did under COPPA, and you really have to think about teens as their own category rather than treat them like adults, and there's certainly good reasons to do that. Many companies just really don't have the capacity to make fine distinctions between the 14s versus the 16, etc., and they're treating everyone under 18 the same. And what that might mean then is that teens aren't getting some of the content they want, because content that is appropriate for a 12-year-old is not the same content as a 16 or 17-year-old who may want content about related to their sexuality or reproductive rights, etc. So um, there are real trade-offs
Mhm.
with the efforts that we're all trying to make to protect teens.
Donna, can I come in on that one?
Sure, sure.
Transparency is one of the standards of the code, and of course, it's features in Article 12 and 13 of the UK GDPR. So, really important for us. I guess we would say that you don't necessarily need um, to tailor as closely as potentially Jessica was suggesting there. Our research finds that the reading age of the average UK adult is probably about 13 or 14 anyways. So if that's the same in the US, then most likely having a privacy notice or transparency notice that is written for the average age of the user will be catching the teen market in any sense. Everybody benefits from serving the teens in that sense. Well, what's possible for an organization to do is to have transparency or privacy notices in multiple formats. So you might have one that's for an adult, you might have one that's written for a 13-year-old, and you might have one that's written for a 10-year-old, for example. And you give the choice to the individual about which one they want to read. In most cases, people will probably go for the shortest, because the research that we've seen and what Pew has shown recently as well is most people don't read the stuff. Don't read it because it's too long, it's too complicated. But our research also shows that when people start to read it, that the level of trust they have in companies starts to drop significantly because of all the stuff that's hidden in these notices. It's really important that companies are upfront and clear about how they process data, and really think about whether they need to be processing all that data. And if they want to build that long-term safe relationship with their clients, they should be doing so in a transparent way, and explaining it in a way that their clients can understand. For companies who want to see how it's done well, on the ICO website, we do have a transparency guidance or champions document that we went out for examples from industry to look for good practice in this space. So that's available on the ICO website if they want to see some useful
Great.
examples.
Yeah, we'll be sure to provide that in the resources that people receive after this. So I think this is a good segue into
I
the.
just want to
Go
make
ahead,
one
Jessica.
clarifying comment, which was I was not just talking about transparency and disclosures. I was talking about content. So um, uh, we're not at odds.
Yeah.
Okay.
Um, so I think it's a good segue into, I think, what has been a really thorny issue for a lot of consumer facing brands, online retail, which is when they see these codes, they don't think these teen and minor privacy laws even apply to them. But when you look at a definition or a level setting that says likely to be accessed by a child or a minor, that may change the interpretation that we're not just dealing with teen focused brands, right? But all brands could be swept up into this. So how important is that? How first, Michael, I know that the UK, the ICO has come out with some guidance unlikely to be accessed by a child and what that means. And I would encourage you, we could start there about how you all have kind of defined that and tailored that definition. And then Jessica and Russ, please, please chime in on that as well.
Sure. The code talks about gives industry choice essentially. So to apply if you first of all, we want to companies that are likely to be accessed by children in significant numbers are in scope of the code. So significant numbers we sort of defined as in a legal sense rather than in the colloquial sense as being more likely than not being not insignificant. So in most cases, if you've got kids on your site, then you are within scope of the code. So this would include, for example, services that are designed for adults, but are used by children. So the UK Parliament was really clear that the code was meant to capture where kids are, not just where services said they are. Now, when we first started supervising the code, we were supervising some games companies that were 18 plus, and they were saying, "Oh no, we're not in scope of the code because we're 18 plus and kids aren't on our site." The reality is that's probably one of the highest selling games for teens in the UK and the world. So it was clear that to us that industry didn't understand the distinction. So we published the guidance to help it understand when they're in scope. Now, generally speaking, any website that has kids on it will be in scope of the code. Now, then that's the first thing, and industry might say, "Well, how do we know?" Well, one of the things that we did, and the first thing we did to know who's in scope, is we did some market research. So we paid one of the market research companies to tell us, well, where are kids online? And they gave us stats that showed, for example, how many teens were on the most highly used porn site, for example. These were in the UK alone, 200,000 a month. So clearly, kids are on these services. So we know they're there. So the first thing to do is look at market research or look at the advertising that's on your site. Are you advertising products that kids are going to buy? Do you see spikes in user access around after 3:30 in the afternoon or in the summer or at Christmas time? Lots of different ways, and the guidance is written with a list of different factors that industry could consider to help them determine whether they're in scope. When they determine that and they find they're in scope, then they can apply the standards of the code to all their users, or they can apply it to only the child users, but then they must know who a child is. So there they need to consider how they're going to do that, how they're going to determine who is a child on their service. And there's different ways to do that we can potentially talk about later.
Yeah, Jessica, I would argue that that list of factors that we've used historically for companies to determine whether or not COPPA applies to them can be translated for making determinations about whether or not you're likely to be accessed by a minor if we're defining that as under 18. So I'll ask you, and then Russ, please chime in as well.
Well, what Michael was talking about did remind me of a little bit of the standard that we've worked with in COPPA for so many years, which is directed to children.
Right.
And when you put meat on the bones of what likely to be accessed by a child or a minor is, then you can get a handle on it. And Michael was talking about some very concrete things like audience composition.
Mm-hmm.
But in the US, that definition has been plopped into proposed legislation without a context. And it kind of freaked people out because if if something is directed to children, well, that's in the you can control that. Okay, is my website directed to children? But when it's likely to be accessed by children, well, there's all sorts of strange places children go that you wouldn't expect them to be on that website, and you kind of lose hold of it. So it it also could cause companies to filter content for everybody or create age verification for everybody, which is, may not be good. It implicates the First Amendment. And, it's for reasons like that COPPA originally did what it did, which is now viewed as flawed, which is it had direct children and actual knowledge because that was ascertainable by companies. And, we've just decided that was flawed, but likely to be accessed by kids is also a problem. So I do think that where COSA and COPPA 2.0, which are two pending kid teen bills in Congress, landed on the knowledge standard was kind of a good compromise, which is actual knowledge of age or knowledge fairly implied based on objective circumstances, because it gets at it's objective circumstances, not this abstract likely to be accessed by children.
Right.
I guess I just add, I take that point. I think so. For purposes of our task force, this is almost not an issue because we're just told to look at what affects the health and safety and privacy of kids online without, there's no directive as to which sites. We, at least at NTIA, have taken that to mean sort of where the kids are. So, Facebook is famous for not being a place where kids like to gather. It's for people, it's for old people like me, to share pictures of their kids who are using Instagram. Uh, but but if Facebook has 3 billion users and only 2 or 3% of those are minors, that's still maybe 90 million people.
Hmm.
And so I feel like we need, and these are companies, not everyone, but the Facebooks of the world and the large companies of the world, they have maybe more information about who their customers are than anyone in any industry. So they have a lot of ability to see this, and I think an ultimate solution will have to account for where kids are going, because to the extent kids are susceptible to harms, benefits also, but susceptible to harms in these platforms, and a lot of them are there, even if they're a tiny minority of the overall user base. Like that's an area where we should be thinking about protection, I think.
Right, absolutely. We have another question from the audience, which is if you create multiple sets of terms for users depending on your age, how do you solve for potential discrepancies between the terms? Everyone, go ahead,
Yeah,
Michael.
I guess, well, you need a good lawyer for that. So go talk to Jessica. I think that's the first thing. But no, I think the general idea is there shouldn't be discrepancies. You can write terms and conditions and privacy notices in plain English, and you can do it in ways, and you can potentially even sort of break up transparency notices in time sort of format. So we none of us read these things because there's too much text right at the beginning of the story of when you're online. If you are delivering what a child or a teen needs to know when they need to know it, you're more likely that they're going to read it. But again, because the reading age, I think, of the adult is lower than the way it's written in most of these, which would needs a university education to understand, it benefits all users if it's simpler. So the first thing is write it in a way that most people are going to understand. In that way, you're probably going to make it understandable by teens, and then present it in a way that most people are going to use it. Break it up, for example, as one example of what you can do.
And as I think Jessica, but it could have been Michael, I apologize, said earlier, like there are times when we want discrepancies where what's appropriate for a 17-year-old is going to be different from what's appropriate for a 7-year-old. There are probably lots of those cases. And it's even the case, I'd say, that there are times when material that's an essential lifeline for a 17-year-old in certain circumstances, we would almost all agree is inappropriate for a 7-year-old or a 5-year-old. And and at some level, difference and the ability to sort of titrate access to content, or at least give parents and kids the tools to titrate access to content, is maybe critical.
Right, right. So, but before we move into, I think some solutions, um, one of those solutions that we're seeing crop up in a lot of the legislative proposals is the use of age estimation or age verification as a potential solution. So I will toss this out to all three of you to chime in on this. What should companies be considering as they develop and deploy methods of age estimation?
Well, I'm going to start with not the solution, but the problem,
Sure.
which is that age verification is just fraught with problems. There aren't a lot of good options. The methods used are often unreliable. They're intrusive. They ask too much information, and many advocacy groups believe all of them inevitably contribute to this age of surveillance and don't believe there should be any age estimation. So, you got to asking birth date. Well, that's unreliable. It's intrusive. Showing government ID, credit cards, guessing from facial recognition or video recordings. That's fraught with problems. Guessing based on online activity, again, very intrusive and unreliable. Questionnaires, and if you read articles about this, everyone recommends third party services. You have an intermediary, and the intermediary, but those intermediary, they're all trying to earn money too, and they're trying to monetize, and so you have to be very careful about using them. How are they going to use the information of your customers, of your consumers, um, And then of course people are talking about a national ID system. So again, I'll come back to, I don't really think the solution in this area is to try to pinpoint uh, age specifically. I think we ought to, when it comes to legal standards, not stick with actual knowledge, but stick with a standard that doesn't force companies to, they can't have their head in the sand, but they also shouldn't be forced to investigate everybody that's online to figure out their exact age.
I think our perspective is age assurance. You should follow a risk-based and proportionate response. So if you are selling alcohol or tobacco or knives to online, or if your service does gambling online, you are legislatively required in the UK to have age verification. So that's part of the system. I don't think anybody would disagree with that. Even our research says parents agree that when it's something harmful, that they agree that that some sort of age verification is a requirement and is a useful thing, and it can be done. It has been done for years. Um, the challenge becomes where it is not that. If you get a sort of a social media site, for example, or a game site, again, from the from a privacy regulator's perspective, we're looking to see where the harms and risks and harms for the privacy are. So if that service wants to avoid using age assurance, then they can look at how they process a child's data. And some of the conversations we're having with some porn companies in the UK, for example, are doing just that. They're saying, okay, well, do I need to share data with third parties? Do I need to use behavioral profiling online? Can I switch that over to contextual profiling, for example, and not process the data? So if the data is not being processed, then the risk level of that service for the ICO becomes smaller. If the company decides, no, it's in our best interest to do behavioral profiling, we want to do advertising, we want to data share because that's how we're making our money, then yes, then they need to start looking at alternative solutions. And what we've seen, for example, is there are solutions out there. Instagram's use of age estimation, 81% of the people going on Instagram are choosing the facial age estimation because it works. And if it can be used in a way that, for example, anybody that looks like me, for example, can just have their face done. There's nothing else there. There's none of the data is retained in the system. Nothing more is done. You just go straight through because obviously I'm over 18. And then if it's closer to the point where the age assurance system becomes potentially less reliable, 2 or 3 or 4 year buffer, for example, then they use what's called a waterfall approach, which might be age estimation. Then it might be something else like how long you've had a mobile phone contract for, or in some cases, depending on the service, you might need to show a hard identifier as well. So it depends on the risk. And I think companies really need to consider the risk, consider what's the right solution for their clients and for them. Just a reminder, the UK GDPR does say that we do consider the current state of technology and the impact on the service, the economic impact on the service. So these are considered as when we balance up what companies should be doing in this space as well.
So, Russ, chime in. I'm also going to ask that we pull the slide deck back up to slide 8, if we can, while we continue talking. Go ahead, Russ.
Yeah. So to be honest, I don't have a strong view on the age verification approaches. I'm looking forward to reading our record when it comes in on those issues to educate myself and clarify my thinking. But I will say something about a broader kind of structural issue. So before coming to NTIA about 2 years ago, I was in private practice for 15 years, counseling companies and arguing for companies. And everyone I worked with in the companies and my clients was really well intentioned and trying to get to the right answer, and really thinking about the common good. Everyone, or virtually everyone, but in institutions, companies, and others, structure matters, and the apportionment of power within the institution matters a lot. So if my job is to think about how do we make sure we're preserving and advancing kids' mental health, and Jessica's in my corporation and her job is maximizing revenue for a product line, and a decision has to be made where we are at odds and we come into a room with a higher up, the person whose job it is to increase revenues and who has a good argument about why this is going to be better for the bottom line has a real advantage unless the person whose job it is to advocate for kids' mental health or whatever social good is really empowered. So my advice to companies, you asked for advice to companies, my advice to companies on this set of issues is to make sure that the people who are charged, if you're a company that is of the size that can have people who are charged with thinking about how do we protect kids' privacy, how do we protect their mental health, even when there might be a hit on revenue, make sure they are institutionally empowered and make sure that there are standard operating procedures for dealing through those conflicts, because those people without that are at a real disadvantage, or
Right.
can be.
Yeah, thank you. We can go to the next slide. I think, many of you who are on the call and all of our speakers know that here at BBB National Programs, we released our TAP, our Teenage Privacy Program roadmap, a couple of years ago with regards to compliance in this very complex space. It was intended, and we know that it's been used to help businesses really figure out how to proactively engage with teen consumers. And the document was really intended to look at the harms and work backwards from those harms that regulators and legislators really are concentrating and focusing on, really what companies should be taking a look at, you know, creating a dedicated process for companies to really understand what those unique needs are for consumers, teens in particular. So when you look at this slide, it kind of gives a sense of where our roadmap shows an additional level of tailored support. And if you go to the next slide, you'll see how we've kind of broken out, these different categories of compliance with regards to some of the more challenging areas. We do have a question before I go to the next slide. If the numbers of kids and teens rather than percentage of the audience count, so if the actual numbers of how many kids and teens you have matter, does that suggest that ads for products like beer or prescription drugs should not be advertised on TV? A quick yes or no, if you want to give a little explanation, because we're short on time. But what does the panel think about that?
I'll just quickly say, the questioner is asking an extremely good question, because there's a lot of self-regulation in the area of alcohol, for example, and it's all based, and other dangerous products, or it's all based on percentages. And yeah, if you went to just a count, I think it would mean those products couldn't be advertised at all.
Right. Michael or Russ? You can pass if you want to pass.
It's a different system in the UK. We have an advertising standards agency which has sets out rules for when advertising of that type can be shown. I think it's after a certain time. So if advertiser or service shows ads that are outside that time, it's the agency, that the ASA that looks at it rather than the ICO. So I'll stop there.
So
it's a percentage at a particular time that is used now to do this type of regulation. Go ahead, Russ. Sorry.
No, I was just going to say, with respect to the questioner, I think it's an imperfect analogy, because we were talking about, looking at, for example, just as an example, what could Facebook do to better protect its young users, because it has a lot of young users. There are things that could be done to protect young users that have no bearing or effect on the adult users, who may make up the majority. Whereas removing an ad from TV is a binary decision, so that the ads can be removed entirely. So I think it's imperfect because there are interstitial remedies that might be proposed or adopted in the online context, where it might not have any negative effect on other users, but would be sensitive to and aware of risks posed to minors. But it is a good question.
Yeah, no, thank you. It's, again, the question just proves why we're having today's conversation, and we're dealing with a very complex space. So what you're looking at now on your screen is, the TAP roadmap that we are updating. Again, it needs to be updated. It was 2 years ago. So much has changed in the landscape. I know we're at time. As I mentioned at the top of the webinar, we are going to provide everybody who's attended with a list of what I believe to be really valuable resources, which include pointing to all the resources that the UK ICO has had, the NTIA comment. We'll provide you with as many resources as we can. And of course, please feel free to reach out to us at BBB National Programs with any questions. Happy to help, happy to engage. I do want to do a shameless plug for our next webinar on December 5th, which will delve more deeply into the topic of age estimation and age verification tools and things like that. So I thank everybody so much. Michael just said if people have other questions and you want to stay on, happy to do so. But I think